phase selection process. I thank all the dignitaries on the dais and off the podium and welcome all the participants on behalf of Akhil Bharatiya Adhivakta Parishad, Devgiri Prant, and request the organizing committee to proceed with the event as scheduled. Thank you very much. Thank you.
Thank you, Advan sir. When I had a discussion with Senior Counsel Mr. Sanjeev Deshpande regarding the legal profession and in fact, a profession which is in delivering justice. At that time he said that it is the most pious work. जसं रक्तदान आहे, ज्याला आपण पुण्य समजतो, त्याचप्रमाणे न्यायदानसुद्धा आहे. की त्याच एकाच फुटिंगवरती ह्या दोन गोष्टी तुम्हाला आढळून येतात. ज्ञानेश्वर माऊलींनीसुद्धा ज्ञानेश्वरीच्या 10व्या अध्यायामध्ये म्हणून ठेवलं आहे, जेणे चोखाळत दिसे न्याय, तो व्यवसायात व्यवसाय, माझे स्वरूप हे राय, सुरांचा म्हणे. आज ह्या न्यायाची उपासना करणारे असे जस्टिस गंगापूरवाला सर आपल्यासोबत आहेत. एक गोष्ट अजून एक अधोरेखित करण्यासारखी आहे की जेव्हा जस्टिस गंगापूरवाला साहेब एका वर्षासाठी चीफ जस्टिस ऑफ मद्रास हायकोर्ट होते, त्यावेळेस त्यांनी एका वर्षाच्या कालावधीमध्ये 52,221 केस त्यांनी डिस्पोज ऑफ केलेल्या आहेत. मी आता फार वेळ न दडवता माननीय गंगापूरवाला सरांना विनंती करतो की त्यांनी आपलं उद्बोधन सुरू करावं.
Honorable dignitaries on the dais, Well, I will directly touch my subject. The Indian Contract Act 1872. This Contract Act came into existence for the first time on 1st of September 1872. But prior to that, how the law was administered. If a dispute had arisen between two Jintus means the Hindus, then the personal law of Hindus was applied to resolve that contractual dispute. If the dispute was between two Mohammedans, their personal law was applied. So also in case of Christians, Parsis and all. But the problem used to arise when the disputants were one Hindu or one Mohammedan. Which law to be made applicable to them? In that case, the law applicable to defendants was made applicable. So the legislature thought it fit to have a uniform law of contract for all the citizens. And then came the Indian Contract Act. Now this Indian Contract Act, when it came into existence, Section 1 said that it applies to the whole of India except Part B states. It was not applicable to Aurangabad, being Aurangabad was a part of Part B state. It was part of state of Hyderabad. But then it was left to those states to apply those laws. Many of the states, because these were princely states, they had made applicable these laws. But as a general connotation, this law applied to the whole of India except Part B states. Then in 1951, amendment was made that this law applies to whole of India except the state of Jammu and Kashmir. So from 1951 to 2019, it extends to the whole of India except the state of Jammu and Kashmir. Then in 2019, after abrogation of Article 370 of the Constitution, now amendment is there, it applies to the whole of India. There is no exception now. In any enactment, you will find a saving clause at the end of the act. But here, you will find that saving clause in Section 1 itself. Because there was no act which was to be abrogated. There was no act which was to be rescinded. Because this was the first time Contract Act was coming into existence. So in Section 1 only, a saving clause is incorporated, saying that nothing herein contained shall affect the provisions of any statute, act, or regulation not hereby explicitly repealed, nor any custom or usage, nor any incident of contract not inconsistent with the provisions of this act. Now, this Contract Act is a general law. Of course, under this Contract Act, there are three types of special contracts also: indemnity guarantee, bailment pledge, and agency. These three special contracts are included in Contract Act. But there are other contracts also. Sale and purchase is a contract. Lease is a contract. Mortgage, partnership, sale of goods, these are all various kinds of contracts. So, these special contracts are dealt with by the special statutes which govern them. Transfer of Property Act would govern sale, lease, mortgage, charge. Sale of Goods Act will govern the transactions of sale of the movable properties, that is machineries and everything. Partnership is also a contract. Partnership Act will govern the disputes of partnership. So, they are governed by their own statutes, these special contracts. So that's why Section 1 says that nothing herein contained shall affect the provisions of any statute, act, or regulation not hereby expressly repealed, nor any usage or custom or incident of contract not inconsistent with the provisions of act. Even a long-standing custom or a usage takes the force of law. So if there is a particular custom, and if that custom is followed, and that is not against the provisions of the Contract Act, that custom also is safeguarded by the provisions of the Contract Act. Now take, for example, there are a cloth merchant society is there. The sale and purchase takes place. The wholesaler sells to the retailer. And there is a tradition that the retailer shall take the goods on credit from the wholesaler and shall pay it within 45 days. And if he does not pay it within 45 days, the wholesaler will charge interest at a rate of 1% per month. Now, the Contract Act does not say what should be the rate of interest. There was no written agreement between the parties about this 1% per month interest to be charged if the amount is not paid within 45 days. But there was this practice amongst them, and this practice was continuing for 40, 50 years. Then it becomes a custom and usage. And so, if a dispute arises between them and wholesaler says that I'm entitled to charge interest at 1% per annum, and he proves that this was a custom, this was a practice, then he is entitled for that rate of interest. So this is why the saving clause in Section 1 itself says that even custom or usage which is not inconsistent with the provisions of this Act is permissible. But there are certain restrictions upon it. This custom or usage should be from immemorial antiquity. Since immemorial times, this practice should be there. It should not be that only for 1 or 2 years this practice was being followed. It should be from times immemorial, say long-standing, 30 years. It should be continuous. There should not be break in this practice. It should be for 5 years it was there, then for 5 years it was disbanded, and again it is being done. It is also, that also does not become a custom. For a valid custom, it should be continuous. It should be from times immemorial. And third, it should not be unreasonable. Take, for example, the custom was that if he does not pay the amount within 45 days, then retailer will pay interest at 4% per month, which will be 48% per annum. This should be an unreasonable one. So even the custom, for it to have the force of law, it should be reasonable one. It should not be an unreasonable custom. Otherwise, it would be an unlawful one. It would be against the public policy, and the agreements or the object or consideration which is against the public policy is void under Section 23 of the Contract Act. So this is what Section 1 says. The second part of Section 1 is relevant to understand that all this contract act is a general contract. These principles are general principles, and other acts provisions also will have to be followed, which you will come across this in various sections of these general principles of contract. Then the second section, in every act, in every codified law, second section is definition clause. Here it is known as an interpretation clause. Here, under section 2, the various phraseologies, the various words which you will come across every now and then in the Contract Act are defined. Proposal, acceptance, consideration, agreement, contract, voidable contract, and when a contract becomes void. All this is defined under section 2. Proposal is when one person signifies to another his willingness to do or abstain from doing something with a view to obtain the assent of that other is said to make a proposal. This is section 2A. So a person should signify his willingness, should show his willingness to the other that he wants to do something or abstain from doing something for the reason that other side should accept it, should consent to that, is said to make a proposal. A says to B that he wants to sell his house to B for rupees 10 lakhs. He is making a proposal to B. A person to whom the proposal is made signifies his assent thereto is said to have accepted the proposal. That is to B. Now this acceptance, how the acceptance should be, is dealt with in section 7 of the Contract Act. Acceptance should be absolute and unqualified. It should be in the same way the proposal is given, the acceptance has to be. It has to be absolute, unqualified, and should be accepted in a reasonable manner. The proposal, if the proposal says that it should be accepted within 8 days, then the acceptance should be given within 8 days, otherwise the proposal will lapse. Proposal will stand revoked. And it should be expressed in a reasonable way. Take for example, A has given a proposal to B for sale of his machinery for rupees 50 lakhs. B, that the parties are residing in Maharashtra. The proposal is given to him in Marathi, and that acceptor communicates his acceptance in a German language. The proposal does not say that in what manner the proposal should be accepted, whether it should be accepted in Marathi only or any other language. But then, accepting a proposal in a foreign language which is not relevant here is not in a reasonable manner. So, section 7 says that if you want to have a valid acceptance as is laid down in section 2B, then that acceptance has to be absolute and unqualified. And secondly, it should be within the time within which it has been laid down in the proposal, or if no time is raised, within a reasonable time. And secondly, it should be in the same manner in which the proposal wants the acceptance should be, or if a proposal does not give the manner of acceptance, then it should be in a reasonable manner. If A has given a proposal saying that he wants to sell his house to B for rupees 50 lakhs, and B says that yes, he is ready to purchase this house but for rupees 40 lakhs, it is not an absolute acceptance of the proposal. So here, what B is doing is he is giving a counter proposal to A. He is giving a counter offer to A. So there, in this case, B will become a promisor who has given a proposal, and it will be for A now whether to accept it or not. So this is what section 2B read with section 7 would require the acceptance to be. Then the proposal and acceptance is not only the requirement for a valid agreement. Something more is required for an agreement to come into existence, and that is consideration. Section 2D deals with consideration. When at the desire of the promiser, the promisee does or abstains from doing, has done or abstained from doing, does or abstains from doing, or promises to do or abstain from doing something, is called as consideration for the promisee. In simple words, this is known as quid pro quo. It is known as quid pro quo, means something in return for something. So unless consideration is there to the agreement is not a valid agreement, or you can say that the agreement has not come into existence only. It is only when a consideration is added to the proposal and acceptance, then only an agreement comes into existence. Take for example, A invites B. B is a friend of A. A invites B at his residence for dinner at 8 o'clock in the night. B goes to A's house for dinner at 8 o'clock sharp. At 7:45, A locks the house and goes out. B has to go back, takes a dinner in a hotel, spends about 1,000 rupees, and now he claims this 1,000 rupees from A. B claims this 1,000 rupees from A. Whether he will be entitled to it, whether there is any consideration to it. You can say friendship is a consideration. No. What the consideration is required is an actual consideration, not an illusory consideration. So what section 2D says about consideration is, though it does not say in specific words, but what consideration is required is actual consideration and not an illusory consideration. It would be an illusory consideration to say that friendship is a consideration. There was no consideration to this one. It was only a gratuitous one that he had just invited him and he went away. So this is what section 2D. When the reciprocal acts are to be performed, an agreement comes into existence. Once a consideration is there for that proposal and acceptance, an agreement comes into existence. But contract does not rest only with agreement. Something more is required for the contract to come into existence. As yet the contract has not come into existence. That agreement should be enforceable by law. So, an agreement enforceable by law is contract. An agreement not enforceable by law is void. So, if an agreement is not enforceable by law, it becomes void. It becomes void means the concept of void is like a stillborn child. A child is born, but born dead. An agreement is there, but it's a dead agreement. No rights and liabilities flow from that agreement. So unless that contract is enforceable by law, unless that agreement is enforceable by law, it does not become a contract. And unless the contract is there, no rights and liabilities flow from that. If an agreement is between a minor, it is void. If an agreement is with an felon, it is void. A convict, it is void. So, an agreement to be a contract has to be enforceable by law. Then that is what section 2H says. A contract which is enforceable at the option of one party only and not at the option of other is known as a voidable contract. So the concepts are void agreement, voidable contract, and contract. Void agreement, not enforceable by law. Voidable contract, enforceable at the option of one party only, but not at the option of other, is voidable contract. That you will see when the consent is not a free consent. It's a voidable one. When the consent is by misrepresentation, it's a voidable one. So it can be enforceable only by one party. And valid contract, enforceable by both the parties. So this is what interpretation clause lays down. Now, first chapter is from section 3 to section 9. It deals with of communications of proposals, acceptance and revocations of proposals and acceptances. It lays on the rules of communication, that how a communication of a proposal and acceptance should be. Section 3 deals with that. Section 3 says that a proposal or acceptance or a revocation of proposal and acceptance may be communicated by any act or omission of a party or which has the effect of communicating it. Which has the effect of communicating. By any act, abstinence, the communication can be there. Now, when this Contract Act was formulated in the year 1872, there were no emails, no fax, nothing was there. But Section 3 has taken care of it. By any act or omission which has the effect of communicating it. By act or omission, by positive act also, and by passive omission also, the communication can be there. Take for example, A says to B that if you construct your house leaving 10 feet margin from my house, I'll pay you 50,000. He constructs his house leaving 10 feet. He has communicated by his act. So communication can be by any form, by any act or omission, and which has the effect of communicating it. Now take for example, A and B are standing in front of each other. A gives a proposal to B that I would sell my house to B for rupees 50 lakhs. B does not say anything, he just nods his head in affirmative. He just nods his head in affirmative whether the proposal is accepted. Whether we can say that the proposal is accepted, he has not said anything, not a single word is uttered. No writing, no verbal communication, whether he has accepted the proposal. The answer would be yes. Because gestures have the effect of communication. What the last words of this section 3 says, or which has the effect of communicating it. It has the effect of communicating. It is another thing whether he will be in a position to prove it or not. That is another thing. But with CCTV cameras and all that, today that can also be possible. It was a distant possibility about, say, 25 years back. But, so, the law has taken though this Contract Act was enacted in the year 1872, it was far ahead of its time when it was enacted. It has taken care of all the eventualities which would be there in future. So this is how communication can be by act, omission, or by anything which has the effect of communication. Contract Act does not require a communication in a particular form only. It can be in any form. It can be verbal, in writing, or even by gestures. Then the other sections about this chapter are just procedural in nature, that when the communication is complete, the communication of proposal is complete as against the proposal when it is put in the course of transmission. Acceptance is complete as against the acceptor when it comes to the knowledge of the proposer, and as far as the proposer is concerned when it is put in course of transmission by the acceptor. So these are the rules only. Then revocation, how the revocation of proposal can be. Revocation of the proposal can be by notice of revocation, by the death or insanity of the person before performance, by not accepting the proposal within the specified time. This is what it lays down. Section 9 of this Contract Act says that contracts may be express or implied. So, Section 9 lays down how the contract can be entered into. It says it can be express or implied. In so far as it is in words, it is said to be express. In words, it may be in writing, it may be verbal, oral, in any way. By telephonic communication, it can be there. By any communication, by return communications, it can be there. Or even contract can be implied from the circumstances on record. This is why it is said that this Contract Act has laid down in a generalized manner the execution of the contracts. The example which I have given, how there can be an implied contract, that A has told B that if you construct his house leaving 10 feet margin, he will pay him 50,000. He constructs his house leaving 10 feet margin. It is an implied contract. The contract was implied. He has accepted that proposal by implication, by his conduct. So even that can form a contract. This is what Section 9 says. Chapter 2 is from Section 10 to Section 30. It deals with of contracts, voidable contracts and void agreements. Section 10, according to me, is the soul of the general principles of contract. Many times you get this question also. All agreements or contracts which are entered into with the free consent of the parties competent to contract for a lawful object with a lawful consideration and which are not hereby expressly declared to be void. So this Section 10 lays down the essential ingredients of a valid contract. For a contract to be valid, what are those ingredients required to be present? It says all agreements or contracts which are entered into, number 1, with the free consent, number 2, of the parties competent to contract, number 3, with a lawful object, number 4, lawful consideration, and number 5, which are not hereby expressly declared to be void. So these are the ingredients which are necessary for formation of a valid contract so as to bind the parties with their reciprocal rights and obligations. There is one more para to it. As far as all these ingredients are there, these 5 ingredients of a valid contract, you will see that from Section 11 to Section 30. This entire second chapter from Section 10 to Section 30 deals with of contracts, voidable contracts and void agreements. Section 10 in a general manner lays down what are the necessary ingredients, and Section 11 to Section 30 will deal with all those ingredients. Now, there is one catch here. The second para of Section 10 lays down, nothing herein contained shall affect the provisions of any law in force in India, not hereby expressly repealed, by virtue of which a contract is required to be in writing, or attested, or registered according to the law of registration. This Section 10 general principle, we will see all that from Section 11 to Section 30. But as far as this aspect is concerned, nothing herein contained shall affect the provisions of any law in force in India, not hereby expressly repealed, not repealed by the Contract Act, not hereby expressly repealed, by which a contract is required to be in writing, or to be attested, or to be registered according to the law of registration. Now, there are certain contracts which are necessarily to be in writing, or which are to be attested, or which are to be registered. Now take for example, a sale deed is executed between A and B. A has sold his property to B for rupees 25 lakhs and a sale deed has been executed. It is registered. But there are no witnesses to that sale deed. Whether that sale deed is valid? Whether that sale deed is valid? The answer is yes. By which law sale deed is required to be attested? Section 54 of the Transfer of Property Act does not require sale deed to be attested. There are certain contracts or certain documents which are required to be attested. Sale deed is not the one which is to be attested. For proof on all that, there is another thing. But the contract in itself is not invalid here. say mortgage, a simple mortgage is it is registered, but it is without witnesses. Whether it is valid? The answer is no. Section 58 of the Transfer of Property Act requires a mortgage, simple mortgage, to be attested by witnesses. So there are certain contracts, certain documents executed between the parties which require that the document has to be attested. Then it has to be attested, and if it is not attested, it would not be a valid contract. Wherever a particular transaction requires attestation, the law says that it requires attestation. It requires witnesses. Mortgage requires attestation. Charge, but lease, sale does not require compulsory attestation. Now, same thing about registration. If there is a transaction in respect of a movable property, it does not require registration. But if there is a transaction of rupees 100 and upwards in respect of an immovable property, then it requires registration. So you will have to go, that's why we go to section 1, saving clause. Wherever other statutes require that a particular transaction is to be registered, it should be registered. Wherever it requires that it should be attested, it should be attested. Attested means signed by witnesses. Attested, or if it is required to be in writing, it should be in writing. So this is what the second part of section 10 lays down. Now section 10, the first para, is all agreements are, normally this question is asked, all agreements are contracts, but all contracts are agreements, but all agreements are not contract. This normally is asked. I don't know about the district judges, but as far as the college is concerned, this is normally the question asked. So section 10 is an answer to that, the first part of section 10. Now, all agreements are contracts which are entered into with the free consent of the parties competent to contract. Now, who are the parties competent to contract is laid down in section 11 and 12. Section 11 says, all parties are competent to contract who are of the age of majority according to the law to which they are subject, and are of sound mind, and are not hereby disqualified by any law from contracting. So this is what competent parties are. All parties are competent to contract who are of the age of majority according to the law to which they are subject, and who are of sound mind, and are not otherwise disqualified by any law from contracting. Sound mind, section 12 deals with sound mind. Now, as far as minority is concerned, section 3 of the Indian Majority Act says that age of majority is 18 years. It says all parties are competent to contract who are of the age of majority according to the law to which subject. So section 3 of the Indian Majority Act says age of majority is 18 years. Now take for example, A, when is a minor, the court has appointed a guardian ad litem to that minor. When it's say 14 years of age, a guardian is appointed by the court of wards. Guardian ad litem is appointed by the court of wards for that minor, for the person and the property of that minor. After he crosses 18 years of age, when he becomes 20 years of age, he enters into a transaction with another person and enters into an agreement to sell that house, sell his house to him for rupees, say, 50 lakhs. Take some advance amount. Thereafter, he refuses to execute the sale deed. The person to whom that agreement was made goes to the court of law for specific performance of contract. Whether the suit shall be decreed. Everything is admitted. Execution is admitted, receipt of part consideration is admitted, the other person proves his readiness, willingness, everything he proves it. Whether he will be entitled to get a decree of specific performance. He was 20 years of age when the agreement was executed. The answer is no. that other person will not be entitled for specific performance of contract because the agreement was void. He was 20, though he was 20 years of age, when he was a minor, 14 years of age, a court of wards had appointed a guardian ad litem to him, and when a guardian is appointed during the minority of that person for his property, then the age of majority rises to 21 years. So that's why it is said, all parties are competent to contract who are of the age of majority according to the law to which is subject. So that's why don't just rely on Section 3 of the Indian Majority Act. Sometimes the age of majority may differ. In this example, the age of majority rises to 21 years. So even at the age of 20 years, this agreement was void. If no guardian was appointed, then it was valid. This is so because there are some, say, Mohammedans. Marriage is a contract. The age of majority differs there for the girl and the boy. The age of majority is different there. So that's why it has taken a precaution, law has taken a precaution, saying that age of majority according to the law to which he is subject. And who is of sound mind. Sound mind we will see in section 11. Sound mind and not otherwise disqualified from contracting according to the law to which he is subject. Now there are many other circumstances by virtue of which a person may become incapable of contracting. He may become incompetent of contracting. Say a bankrupt person, a person who has been declared insolvent, who has been declared bankrupt, that is his civil death. If a person is declared insolvent, it is his civil death. He is not entitled to enter into a contract, and any agreement with him would be void. A felon or a convict who is undergoing a jail term, during that period he is not competent to enter into a contract. Alien enemy. Alien enemy is a person who is a citizen of a country against whom India is at war. So alien enemy, he is not entitled to enter into a contract. Or the ambassadors and the diplomats of foreign countries, subject to some exceptions only, a contract can be entered into with them. There is some procedure which is required to be followed. So these are some of the persons who are not competent to enter into contract, and so they are incompetent parties to enter into the contract. Section 11 says, what is the sound mind for the purpose of contracting? A person is said to be of sound mind when at the time of entering into the contract, he is in a position to view his interest in that contract. Then it can be said that he is a person of a sound mind. He can form a rational judgment as to his interest in that contract. Then it can be said that he is a person of a sound mind. A person who is normally of a sound mind but occasionally of an unsound mind cannot enter into contract when he is of unsound mind. Or a person who is normally of an unsound mind but occasionally of a sound mind may enter into the contract when he is of a sound mind. This period when he is of a sound mind, that a person who is normally of an unsound mind, but for a certain period he becomes a person of a sound mind, this is known as a lucid interval. This is known as lucid interval. So that time he can enter into a contract. How do we come to the conclusion that at the time when he had entered into the contract he was of a sound mind or not? It is only on the basis he is said to be of sound mind when at the time he enters into a contract he is in a position to form a rational judgment as to his interest in that contract. That is the definition of a sound mind. This is what section 12 requires. Now this is regarding the parties competent to contract. Then another ingredient is free consent. Section 13 defines consent. Section 13 says, two or more parties agree to consent when they two or more parties are said to consent when they agree upon the same thing in the same sense, which we call it in legal parlance as consensus ad idem. This is known as consensus ad idem. Two parties agree upon the same thing in the same sense. But section 10 does not merely require consent, it requires something more. All parties are competent to contract, that is one, and consent should be a free consent. All agreements or contracts which are entered into with the free consent. So consent is not only sufficient, that consent under section 13 should be a free consent. And what is a free consent? Section 14 defines what is a free consent. Section 14 says that a consent is said to be free if it is not caused by coercion as defined in section 15, undue influence as defined in section 16, fraud as defined in section 17, misrepresentation as defined in section 18, and mistake subject to the provisions of section 20, 21 and 22. This is the definition of free consent. That it should not be caused by any of these ingredients. And all these ingredients, one special section has been allocated to each ingredient. Now first is coercion. What is coercion? Section 15 defines. Coercion is committing or threatening to commit any act forbidden by the Indian Penal Code, or unlawfully detaining or threatening to detain the property of any person whatever to his prejudice, so as to induce him to enter into the contract. There is a short explanation to this. It says it is immaterial whether provisions of IPC apply where the coercion is employed, where the coercion is exercised. So this coercion is committing or threatening to commit any act forbidden by the Indian Penal Code to the prejudice of any person whatever, so as to induce him, so as to force him to enter into a contract. Now take for example, A comes to B and says that if you don't sell me your house for 10 lakhs, which is worth more than 50 lakhs, if you don't sell your house to me for rupees 10 lakhs, then he will kill him. He comes with a knife in his hand. There is an imminent danger. B agrees to enter into the agreement. This is a coercion because he has threatened to commit an act forbidden by the Indian Penal Code. Take another example. A kidnaps the son of B. A kidnaps the son of B and tells C that if he does not enter into a contract with him, if he does not sell his house to him for rupees 10 lakhs, which is worth much more, then he has already kidnapped the son of B, he will harm him. That, and C has entered into the agreement with him, agreeing to sell the house for 10 lakhs, which may be worth 1 crore. Then